Case number 117357 in the matter of Jeffrey A. Sutton. As I mentioned at the 9 o'clock docket call, we would have a recusal on this case. Justice Marlo Lukert is recused, and sitting in her place to my right is Judge Catherine Gardner from the Kansas Court of Appeals. Judge Gardner has read all the material. She'll be participating in the oral arguments, the case conference this afternoon, and the ultimate resolution of the case. Judge Gardner, on behalf of my colleagues on the court, I'd like to thank you for helping us out today.
You're very welcome. It's an honor.
Very good. Counsel, you may proceed.
May it please the court, Stan Haslett appearing from the Disciplinary Administrator's Office. I'd like to reserve 2 minutes, Your Honor.
2 minutes is granted.
This is an attorney discipline case that's before this court as a result of a hearing which occurred on November 10th of 2016. The matter was docketed by the clerk's office on March 15th of 2017. Briefly stated, the facts are as follows. They're really pretty straightforward. The respondent represented the wife, A.C., in her divorce. The parties resolved most of the issues except for whether the children were going to go to school. On May 15th, May of 2015, Judge Nafziger, who was the trial judge in the case, ordered that the children attend school in McLouth rather than Tonganoxie, where the respondent's client moved after the May hearing and remarried. She wanted the children to go to Tonganoxie. On June 24th of 2015, the respondent filed a motion and requested that the children be allowed to attend school in Tonganoxie, in other words, changing what Judge Nafziger's previous order was. On August 24th of 2015, the respondent sent letters to the principals at both schools, McLouth and Tonganoxie. And in that letter, I'm not going to read the whole thing, but the pertinent language is, as a consequence of this new residence, my client has filed an application with the district court that has jurisdiction over the matter, seeking to have a determination made about the district where the children will attend school moving forward. Because my client's motion is pending, it is scheduled for a hearing on September 9th of 2015. There is no order to resolve where they will be attending school. That last portion is the significant language. The respondent has acknowledged that the language in the letter was not accurate, that there was a valid court order in effect that required the children to attend school at McLouth. The respondent's client had enrolled the children in the Tonganoxie School District. These two letters that went to the two principals, and the language in those two letters are the subject of this disciplinary case. The respondent stipulated that he had violated KRPC 1.4 on communication. He explained that he was required to explain to his client exactly what that court order meant, and that she had an obligation, obviously, to follow that court order. The panel found that the respondent had violated 8.4D, which is conduct prejudicial to the administration of justice, and they found that this rule was violated by sending the two principals the letters containing what they describe in this portion of the panel report as inaccurate information, which led to confusion, which resulted in his client violating the court's order. Mr. Petlon, who represents the respondent, and I agreed as to a procedure during the hearing, and that was that his client would testify, and after the client's testimony, the panel would then determine whether there was a violation of 8.4C, which is conduct involving dishonesty, fraud, deceit, or misrepresentation. Mr. Petlon's client, Mr. Sutton, did testify, and after that, in the panel report, you can see that there was a finding that there was dishonest conduct based on that statement that was in that letter. On March 23rd of 2017, the respondent filed a notice under Supreme Court Rule 212 that he did not take exceptions to the findings of fact made by the panel. The recommendations made to the panel, first by the respondent. The respondent said, well, would you consider informally admonishing me? Secondly, if you don't informally admonish me, would you publicly censure me? Third, if you don't do one of those two things, would you place me on probation? And the respondent submitted, which I believe is your Exhibit A, a probation plan, which, as I read it, requires the respondent to consult with an attorney that he's known for quite some time, to sit down and talk about their files, and for this to go on 24 months. And if the supervising attorney has any sort of question about any of the cases, then he is to consult with this lawyer. The panel recommended to this court that the respondent be publicly censured. The panel members believe that the respondent they stated in their report that the respondent had properly reflected on his behavior. He recognized what he had done, and it was obviously wrong, and that he was remorseful. And I'm going to agree with that. It's when you actually sit in and see the respondent speaking to the panel, and I think the panel, in making this finding, recognized, in their opinion, that the respondent was sincere in what he was saying, that he knew he'd messed up. They also concluded, based on the testimony given by the respondent, that the chance for future misconduct they felt was remote. They then cited two standards in support of published censure, which is contained within the panel report. I was torn by the recommendation in this case. I mentioned before the procedure that Mr. Petalon and I agreed upon, which was we'll submit to the panel the issue of whether or not the respondent engaged in dishonest conduct. What I said at the hearing was that if the panel made the finding that the respondent engaged in dishonest conduct, that I thought a short suspension was obviously justified. And the panel did make this finding. With respect, it's kind of confusing though when you read the panel report, because with respect to 8.4D, they don't find that it's dishonest conduct. They found that he provided inaccurate information, and they found that he acted negligently throughout this situation, as opposed to intentionally and knowingly. So there are some kind of conflicting messages being sent. Again, they cited two standards, ABA standards, which they felt justified their recommendation. And most importantly, I think, based on the testimony of the respondent before the panel, they concluded that they just didn't think this was going to happen again. They concluded he was remorseful. Obviously, this misconduct is serious. There's no question about that. As I said, I struggled with the recommendation on what to make in this case. The recommendation to make in this case, I don't think, obviously, informal admonition is appropriate. I don't think public censure is appropriate. I think the appropriate recommendation now, and you can make the argument for suspension as well, but the appropriate recommendation now is the probation plan, acceptance of the probation plan submitted by the respondent in this case. And that's what I would recommend here today.
How do we reconcile that probation plan with the notion that the panel's finding that the chances of reoccurrence are small? I mean, traditionally, I look at the probation plan as, keeping an eye on somebody because they have a characteristic that might flare up again, and this seems to be kind of a one-off as I look at the hearing report. So why do you embrace the probation plan?
Just to be careful, just to be safe, so that the respondent is in fact meeting periodically with another lawyer to discuss problems that might come up in his practice.
Well, is that also balanced by the seriousness in which you take the violation here too?
Right. I mean, because it would be very easy to stand here and make the argument that the respondent ought to be suspended. I mean, you can look at those standards and conclude that.
I note under paragraph 33 of the final panel report, that the final hearing report, that under injury, they found that actual injury to the client, to the public, to the legal system, and to the legal profession. Was there any discussion about injury to the child? We're talking about making misrepresentations that would impact where the child went to school and how long the child would be in school and whether they would be
Right.
jerked out of one school and put into another. Was there any discussion of that aspect of it?
There was no discussion as I read through the transcript of that.
Do you disagree that
No, I don't.
children were innocent victims of this
I-
fight over the elementary school?
I absolutely agree.
Just so I'm clear on your summary, counsel, you want a public censure and a probation plan that the respondent submitted?
Well, I think the probation plan that he submitted suggested it last 24 months. So I would say that that there be a period of suspension with the respondent being placed on probation, and the suspension be stayed during that period of time.
Do you have a period in mind?
Well, I would go with what the respondent said. He said 24 months in his plan, I think is correct. Yes, that's right.
For the suspension?
Yes.
And it did not appear that the panel said, yes, we think a probation plan is appropriate.
No, and I think that probably goes back to what Justice Biles just said. I think they felt like it was, the chances were remote that he would engage in this sort of misconduct again. So I can only deduce that they must have concluded that they didn't think a probation plan was necessary. I just disagree with that.
And is it because you see that they did find he had engaged in dishonest conduct?
Correct.
Okay.
I mean,
Even,
there's no arguing that the misconduct is very serious.
any more questions? All right, thank you, counsel.
May it please the court, the respondent Jeffrey Sutton appears with his attorney Trey Putland. Mr. Sutton agreed that he violated rules 1.4b in failing to adequately communicate with his client and 8.4d by engaging in conduct that was prejudicial to the administration of justice. The hearing panel also concluded that with his August 24 letter, Mr. Sutton violated 8.4c and that he misrepresented the order of the court. The hearing panel determined that Mr. Sutton's actions were the result of negligence, that he did not intentionally act in those violations, that his conduct was isolated and not likely to recur. The panel, as you can see, ultimately recommended public censure. And it's clear that, as Mr. Hazlitt said, that the panel was impressed by my client's sincere remorse and by his acceptance of responsibility for his mistakes. I had really been prepared to come here and argue that informal admonition was a more appropriate discipline than public censure. In the time that we've had this morning, I've had a lot of discussion with Mr. Hazlitt, and I could see why intelligent people might disagree with me. I could also see why they might disagree with Mr. Hazlitt. And so I certainly wanted to present the possibility that my client could continue on a 24-month probation if the court thought that sort of additional assurance was appropriate. I certainly want to argue against a short-term suspension. I'm hoping the court will be impressed by my client and by the arguments here today. Mr. Sutton will have a few words when I am finished. To expound on Mr. Hazlitt's remarks, after Judge Nafziger made his ruling that the children attend school in McLouth, Mr. Sutton's client, AC, unilaterally made the decision against Mr. Sutton's advice to enroll the children in school in Tonganoxie, contrary to the court's order. AC enrolled the children in the school in Tonganoxie on August 6, 2015. Mr. Sutton did not become aware of her decision until August 24. That was uncontroverted. So after AC had already made the decision, and after the children had already begun school, which began on August 20. The week before my client found out about AC's decision, and the week before her discussion with him, AC contacted Mr. Sutton's office and spoke with his staff and said that she needed to speak with Mr. Sutton because her ex-husband had given a copy of the court's order to the principal at McLeod, and the principal at McLeod had shared that with the principal of Tonganoxie. And it was, at the time, Mr. Sutton was in a 2-day trial in another jurisdiction. So for the first time he had an opportunity to speak with AC and to discuss this matter with her was on Monday, August 24 of 2015. Mr. Sutton first tried to convince AC to remove her kids from school in Tonganoxie until the court had a chance to rule on his motion. He had previously filed a motion to modify the order, and that was scheduled for hearing in approximately 2 weeks later on September 9. But the evidence was clear that AC was not receptive to that idea. AC was convinced that the school in Tonganoxie was in the best interests of her children, and she would not be dissuaded. She was also very upset that the hearing to modify the order wasn't scheduled until September 9, which was after school began. She implored Mr. Sutton to write a letter on her behalf to the principals, basically to indicate that the motion was pending for reconsideration. She was frantic. She hadn't been able to reach Mr. Sutton for several days, and she was afraid that the children would be removed from school in Tonganoxie and moved back, consistent with the court's order, to school in McLeod. And Mr. Sutton at this time enters the situation sort of in the aftermath, how to deal with it in the aftermath. And in that moment, he made his very, very poor decision to write that letter that's dated August 24, 2015.
Counsel, before you proceed, I'd like to look at the finding of fact by the panel number 23. It says the mother was called to testify, and she testified that the respondent gave her legal advice that led her to disregard the court's order. The court concluded that the mother's violation of the court's order was induced by the respondent's legal advice. So can you help me pin that date down, what she's talking about?
That Chief Justice Nuss, she testified at a hearing after my client was no longer in the case, not at the hearing on the discipline before the panel below, but at a hearing in
Judge Nafziger,
in
right?
Judge Nafziger's court on November 4, 2015, after my client had withdrawn from the case.
But sorry, I wasn't more specific. What is the time that she says she got legal advice from your client that she relied on, and that led her to violate the court's order?
That's unclear, because it is clear that my client didn't know about her enrolling her children in the school in Tonganoxie until August 24. And there were discussions that were off the record after that decision was made by Judge Nafziger. But my client did advise, and the evidence is that my client did advise her that she needed to comply with the court's order. Where my client went wrong on August 24 also to violate Rule 1.4b is by writing a letter to the principals basically saying that the motion was still pending and that the matter was still subject to review. He essentially ratified my client's or AC's decision, and he essentially, again, confused the message with her. He didn't communicate, and he admits he did not communicate sufficiently to enable her to make an informed decision in violation of 1.4b.
Is she saying that she enrolled her children in the Tonganoxie district based on what she understood was legal advice from your client to disregard the court order?
Apparently, that's what her testimony was in that hearing.
And that's what Judge Nafziger then found.
Yes, that's right. Now, my client did not testify at that hearing, and there was no evidence presented on his side. I would submit by that point, Judge Nafziger was very clear that the decision to have enrolled the children into school in Tonganoxie was unacceptable and was contrary to his order. And at the hearing where my client basically became advised that that his letter was a reportable offense, Judge Nafziger at one point said something to the effect of, potentially at the next hearing, somebody's going to go to jail. Something to that effect. And clearly, at that point, AC is going to say, I relied on my client, on the advice of my attorney. And she did. I mean, but my point is, my client did say to her, obviously not very effectively, that you need to have your children enrolled in McLeod until my motion is heard. He filed a motion. He scheduled it for the earliest hearing that he could get, that all the parties were available, but it was after school began. And there was email correspondence back and forth from AC to my client's office, which makes it clear. And also there was an exhibit regarding from my client's administrative assistant about her conversations with AC, which make it clear that my client had no idea that she enrolled her children into school in Tonganoxie until August 24.
And as I understand what you've told us, on August 24, the respondent became aware that the kids were enrolled and became aware that the principal or someone in the administration in Tonganoxie had a copy of Judge Nafzinger's order.
That's right.
And then he writes a letter that says there is no order.
Right.
And so my question is, how is that negligent? How can that possibly be a negligent act?
Because what he was saying, what he was trying to convey erroneously, because he didn't, quite frankly, I think what the panel determined was he didn't appreciate the finality of the order. In other words, that this is the order now, and just because you filed a motion and we have a hearing.
I suppose that might make some sense to me if the respondent didn't write this because he knew the principal at Tonganoxie had a copy of the order. But that seems to me to be a very important fact. If your client knew that the principal had a copy of Judge Nafzinger's order, and then he proceeds to write a letter saying there is no order.
But I think that bolsters my point. And my point is that my client didn't have any delusions that they didn't think there was ever an order, that the principals didn't think there was never an order. His wording was terrible. His craftsmanship of the letter was terrible, which is why possibly that the panel went on to say at the end that the respondent should have carefully, this is in their final paragraph, the respondent should have carefully read the letter prior to sending it to make sure that it accurately reflected the court's order regarding school attendance. That admonition would not make any sense whatsoever if my client intentionally engaged in dishonesty, if he intentionally tried to mislead the principals. But he negligently stated basically that the order, Judge Nafzinger's order, was still subject to litigation because we filed a motion and we've got a hearing and the hearing's just in 2 weeks. And what he did, and my client has been unequivocal about this, What he did by writing that letter, and it doesn't really matter how it's worded, it violates 8.4D because it delays the effective date of the judge's order. It is contrary to what the court's order is. It is prejudicial to the administration of justice. It's also inaccurate. It's a misrepresentation of what the court's order is in violation of 8.4C.
Counsel, let me direct you back to the earlier discussion. And my concern is in finding of fact number 23, that is one of the findings that you and your client have not taken exception to. So we have an agreed upon basically finding, or unobjected to finding, that she took the children to Tonganoxie in the first place based on your client's advice, and then that's followed up several weeks later by this letter that he sends to the principals in which he misstates whether there was an order resolving the situation. So it kind of gets back to a question I think that Justice Stiegel raised, and how it is, if you put those two events together, how can that be negligent misconduct if there is such a thing?
Chief Justice Nuss, I would respectfully disagree with your analysis on paragraph 23. On paragraph 23, we've stipulated that on November 4, the court resumed a hearing. The mother appeared with new counsel. The mother was called to testify, and she testified that the respondent gave her legal advice that led her to disregard to the court's order. That was her testimony. We've stipulated to that. The court concluded that the mother's violation of the court order was induced by the respondent's legal advice. We've stipulated because that's what happened in that hearing. We're not admitting that my client actually did try to induce her to, the evidence was uncontroverted, that he did not induce her to initially enroll the children contrary to the court's order. That came out in exhibits.
But don't we have a finding that you do not take exception to that was made by Judge Nafziger that found that your client induced his client to violate Judge Nafziger's court order? And I thought you told me earlier that that was a reference to something before he wrote the letter to the two principals on August 24, which she, I suppose, could say, well, that tells me that I can violate what's going on here because my lawyer's telling the principals that's not been resolved yet. There is no order in effect, so I can continue doing what I'm doing. That's what I'm putting together. So if you have a response, let me know.
Thank you. I do agree with that last thing that you just said, that last part of what you just said, that my client did, in no uncertain terms, give his client the wrong message and fail with regard to communication with his client when he sent that letter on August 24. He essentially ratified what her decisions were before he talked with her. And he certainly confused, I think, confused her about what she could do and what she could not do.
My point is that you said he ratified her conduct, and according to Judge Nafziger, the conduct was induced by him earlier. That's what I'm trying to put together.
Judge Nafziger made that finding without any testimony from my client.
I understand, but it's a finding that's in the record, and you've accepted, you have not taken exception to the report.
I guess what I am, and with all due respect,
That's fine.
Maybe I'm mistaken here, because what I was trying to do when we didn't take an exception to that paragraph, my understanding was we were just simply stipulating that those things that the court did in fact make that conclusion, which he did.
Those things occurred at the hearing. You were agreeing that those things occurred at the hearing.
That's
you were
right.
Not agreeing that the substance of her testimony was accurate.
That's right.
Or that his ruling was legally correct. You
That's
were just
right.
saying those things happened at the hearing.
Yeah, we cannot contest the fact that those things happened at the hearing.
And also, there's no finding of fact by the hearing panel that Judge Nafziger was correct in his conclusion that your client induced. All you're doing is just saying, yeah, that happened at this court hearing.
That's right.
You're not saying that you're not taking the extra step and confirming that it's true.
That's what we're trying to convey.
And in fact, the panel found in paragraph 24 that the respondent disputes the statements made by his client, which led to the court's conclusion, et cetera, et cetera. So you've preserved that argument that you dispute the conclusions.
That's right. Thank you very much. I had meant to defer and leave my client a little bit of time, and I didn't. What the court would prefer.
If he would like an opportunity to address us, that'd be fine.
Thank you.
Very much. Inasmuch as this happened almost 2 years ago, I've had a lot of time to reflect on it. Sorry, give me a second here. Had a lot of time to reflect on what happened, what my part is to play. I recognize that our system is built on a foundation of the court working and making orders, and that attorneys, as officers of the court, are part of the process in enforcing that. In running that through my mind all these months and looking at the letter and figuring out why I did and what I should do moving forward with respect to this, I asked myself about the letter. If I was in this situation again, I would not write this letter at all. Not just the objected language, but the letter at all. I would write a letter to my client reiterating what I had already told her, and that is that she should be following the court's orders. I want to just back up a little bit. That order that was in question first originated when my client was at a hearing where she was represented by somebody besides me. So the court made a ruling, I'm going to make this up, let's just say in January, relative to August when this stuff happened. And then when it came back around, it came up at the tail end of the hearing and it was reaffirmed by the court. That's the hearing I was involved in. That's the journal entry I think that you all have that contains that language at the very end. So she was represented by an attorney, another attorney the first time, not me, when the court made the ruling. The court reaffirmed the ruling at a later hearing, and then we talked about that after the hearing. They have a jury room in Jefferson County, and we went to the jury room and we talked about the substance of it. And then the issue didn't come back up again until I get back in the office. I was out of the office for a 2-day trial, and when I got back in the office, she had called while I was gone, but unavailable, and was calling that day to say she had enrolled her children in the Tonganoxie School District, that her husband, who was best friends with the principal in the McLeod School District, had shared the court's order with the McLeod principal. You know, I need help. That's where my reflection on this changes the way that I would do things. In this sort of protecting the justice system, I had no place sending a letter to the principals that basically tried to promote my client's violation of the court's orders. Okay, it's not, I didn't intend for the language, and I'll address that to be in a minute, but I shouldn't have sent the letter. They depend on us. They depend on me to get it right, and trying to support or enforce my client's decisions to violate the court's order to people outside the judicial system. They don't have the benefits that I have of education and experience, or that you all have. They see what they see, and so I'm comfortable and confident that I should never have written that letter in its entirety, and I would never do that again. I didn't think two thoughts about this letter until the hearing when it came up. And I was so embarrassed and disappointed when we were in court, and I hear then for the first time the fateful language that the disciplinary administrator illuminated to you. I was simply intending to say, we don't have an order on our motion. I said in the letter, we're filing a motion to amend the order. Now, I didn't use exactly those words, but that's basically what it said. I used voice recognition technology. I dictated it, I read it, and I sent it out by email, not by regular mail. My policy has been, and my policy continues to be, that when I do those kinds of things, when I dictate stuff, I have 2 people who work for me. My stuff gets reviewed so that I don't make mistakes in dictation. I didn't do that in that case. It was late in the afternoon. My client was very clearly in my ear, and I was trying to do something. It's clear to me that irrespective of clients' wishes, we don't always have to support and try to defend the things that they do. And I got in such a hurry that day that I lost sight of the notion that that's really the responsibility that we have. I feel like I have let Judge Nafziger down. I first appeared in front of Judge Nafziger in 1993, 1994, and then have appeared in front of him throughout the years. And one of the things that you'll see in the record is that we had no problems. I am extraordinarily confident that nothing like this will ever happen again. I didn't intentionally mislead someone, but putting it all together and not writing the letter and not proofing it properly has cost me dearly, and I will never let something like this happen again.
Let me ask a question, and I think it's more fair to direct this to counsel rather than to the respondent. What do you think you're going to get out of probation under the facts of this case? I'm still wrestling with
Maybe
the benefit.
Well, I think we all can be reminded no matter where we are in life, we could be reminded by our peers on a daily basis or frequent basis of what our obligations are, and we can discuss ethical issues. So I don't think that there's anything negative to having a probation plan. I had asked for I was going to ask for the informal admonition because I really have come to believe that the complaint process is much more effective than maybe I ever thought before. I think it reaches people, and I think it's reached my client already. I think it reached him when he got that complaint. I think it reached him when Judge Nafziger said that this was a reportable offense. And I think that it's changed his life in many ways. And I think that this process in many regards has been a success. But getting to your question, if it gives Mr. Hazlitt any comfort, that would be a benefit. I honestly, my client would be happy to do a probation and continue.
Here's the deal. I mean, often when we do these, we suspend the lawyer and then suspend the suspension. And then have the probation plan, and the suspended suspension is the sword hanging over the respondent during the probationary period. But that tags you as having an order of suspension, even though it was suspended. And that has a level of severity to it that I think is greater than published censure. And I'm trying to balance off, I think you're trying to short circuit us having, what kind of a hammer we might have during the probation period that we typically put in these orders. So I'm just trying to weigh what everybody gets out of this deal.
I think that this is a case, just judging from a lot of conversation with Mr. Hazlitt, that intelligent people can certainly disagree about. And there's a lot of, personally, I've seen how even a published opinion, how that impacts a practitioner, and especially a sole practitioner. Maybe I'm biased there, but I can see it when when they, people increasingly are trying to find their lawyer with internet research, etc. And I just think I know my client has got the point, and I know that what he did was negligent, which was consistent with what the hearing panel determined, but given their, I'm sorry.
Well, I was taking advantage of your pause. I'm just trying to understand your position. It sounds to me like you're saying that you are advocating for and your client would prefer the disciplinary resolution suggested by Mr. Hazlitt, i.e. a suspended suspension with probation in lieu thereof, in lieu of the suspension. You would prefer that to a public censure. That's what it sounds like you're saying, but I'm not.
And let me add to that,
Okay.
because the way we do these probation plans, it's gonna be a published order, unless we
That's-
designate it as not being published.
Okay, I'm glad for the clarification, because I was admittedly confused. I think that certainly what I would urge the court to do would be the public censure as opposed to the probation.
Yeah, if you're talking about increasing levels of severity, then
Yeah.
that's really more positive.
I certainly agree, and my client would prefer that.
That would be your request if we decide to impose any discipline?
Yes. And that was my request as an alternative at the hearing panel. Yeah.
Any further questions? Thank you both, counsel.
Thank you all.
We reserve 2 minutes for rebuttal.
Mr. Chief Justice, I would waive rebuttal unless the court has any questions of me.
Any questions? I see none. Thank you.
Okay.
We thank all of you for your arguments this afternoon. Court will take this matter under advisement. This time